And today I will be exposing State Farm's corporate greed, and I will be exposing State Farm's lawyers for their unconscionable practice, as I was hit head on and struck by their insured while I was at a red light, and they have been lowballing me every step of the way. So I decided to sue State Farm, and now I will outline the lawsuit timeline, and I will show you guys from the police report how they have been trying to lowball me, even though they know that they're in full fault, and they have admitted on paper that they are in full fault and liability. So the first things first is we're going to jump right into the police report. Here's the police report front. Unit 1 is State Farm's insured, Mohammed. Unit 1 is me, Isaac. Here is the back. Unit 1. Unit 1 was heading northeastbound on Hollywood, turning into Ridge, when the vehicle skid into Unit 1 because of snow and slush due to the weather. Unit 1, Mohammed. Unit 2, myself, right there at a red light, sitting in my own lane, following the rules of the road. How can you not pay up when you totaled my car and you continue to lowball me and undermine my intelligence? This is why you got sued, and this is why I'm exposing State Farm and State Farm's lawyers, because it's as clear as day right here. So now we're going to jump in, and I'm going to show you how the accident happened. So defendant is driving in the direction of this green arrow. As you can see, here is a sharp turn onto Ridge, as the police report noted that notes here 15 miles per hour. Here is the defendant's turn. And here is the defendant supposedly turning from that angle. This is from a looking at him, looking at the defendant. And here is as the defendant turns. As you can see, the green arrow indicates the direction of the lane that belongs to the defendant. Instead, he turned onto oncoming traffic, which was me sitting at this red light right here, and he took the path of that red or pink arrow. Here I have illustrated it clear with the pink arrow right overlapping the lane that I was in, where the white car is sitting. As you can see, right underneath the pink arrow, there's a white line where you're supposed to stop because there's a red light there. I was at the red light waiting for my light to turn green. However, he was turning way too fast and was not taking the fact that there was about 2 inches of snow on the ground into consideration, and he was driving as if there was no snow, hit me head on. So here we can see it from another angle. Where he was supposed to follow this green arrow here. Instead, he turned onto me, oncoming traffic. As you can see there, there's a turning lane right there where I was at. Here it is from another angle. Defendant drove off his lane and into oncoming lane. Defendant's lane supposed to be green arrow. See, I was sitting right here, following the rules of the road at my red light, in my own lane, minding my own business. Here we have it from another angle, and I am supposed to be this red car over here, or this maroon car, as this red little Geo-looking car was supposed to be him following the green arrow. And now I will show you guys these photos one more time in a bigger context, in a higher quality. Here we are. Bigger. You can see here there's several lights and it's turning. Here's my red light right here. And then here's a bigger photo here. So this is him, the defendant. He was supposed to follow the green arrow. Instead, he deviated onto the red arrow and hit me. So then I will now jump into the lawsuit because you have now seen the police report. Clear as day. So I have a website, Isaac-versus-vs-statefarm.com. And when you tap on the lawsuit, it'll load up the PDF. It's already been filed. It was filed in 2019. The accident happened in 2017. Here we are. On and on before December 24th. It happened on Christmas Eve 2017. And we'll jump straight to the meat of the actual lawsuit. And this is the part where I am exercising my right to claim the damages that are owed to me. And State Farm and their lawyers are pretending like the police report doesn't exist and like this lawsuit doesn't exist. And all they've been doing in court is throwing legal technicalities at me in order to tire me out because I'm pro se and they don't want me to win. So the defendant owed a duty of reasonable care in the operation of his motor vehicle in order to avoid colliding, striking, or contacting pedestrians, cyclists, or other vehicles on the roadway. Defendant exercised negligent act and carelessness in operating his vehicle at a speed that was greater than was reasonable given the traffic conditions, was in violation of 625 Illinois Code Section 511-601. So I am putting out this in legal writing that he owed a duty to drive and operate his motor vehicle in a reasonable fashion with respect to the weather. These are the laws. This is the code, the law. This is for real. So as a direct and proximate result by defendant, plaintiff has been physically injured, financially injured, suffered a complete loss of motor vehicle, and has lost wages and undergone emotional distress, mental distress, and inconvenience. And now I'm letting them know that I am seeking $29,752.87 in damages. So now we're just going to jump right into the timeline. We're going to jump right into the timeline, which I have hosted on the Isaac-versus-StateFarm.com domain. This is public information because this is supposed to be a public trial. So, December 24th, 2017, defendant crashes head-on into plaintiff's, Isaac's vehicle while plaintiff is at a red light. Plaintiff calls State Farm, defendant's insurance, and registers the claim while at the scene. Okay, right after that happened, I came out of my car and I started yelling at the dude. I was like, yo, it's clearly snowing. There's snow on the ground. How are you not aware of the fact that you cannot operate your vehicle in the same fashion as when you operate your vehicle when there isn't snow on the pavement? Like, when he turned it on, when he was driving the blocks before he got to that intersection, he had realized that the motor vehicle was not operating in the standard fashion that it does when there is no snow on the ground. So I get out and I start yelling at the dude like, yo, what the fuck is wrong with you? Like, bro. And I was like, give me your insurance. Like, I'm calling this in right away. Because it's like, I was sitting at a red light. I was doing nothing. December 26, 2017. Okay, this is now 2 days after the accident. So I, plaintiff, receives mail correspondence from State Farm confirming phone call. The phone call that registered the claim right after the defendant crashed into the plaintiff being me. I'm going to be speaking in third person for the rest of the video now. State Farm discloses and affirms an agreement with respect to plaintiff paying for vehicle tow storage fees. False. Plaintiff was coerced over the phone. State Farm said something to the effect of, until we have the police report and we investigate the claim, you have to pay for the towing and storage of your vehicle. After their insured just totaled it. Now I still have to pay for towing and take care of where I'm going to put my now totaled vehicle. Okay, so then here is the mail that they sent me, December 26th, and it says, this confirms our conversation in which we discussed that you will be responsible for any towing and storage cost incurred after December 24th. Okay, so here's December 28th. I thought that I was going to get a police report in the moment. No, the police said, look, we're going to give you a police report number. You're going to have to go in person to a police station, pay for the report, and then you'll have the report. So I had to wait 4 days until that processed. So here it is. I went on, where's the date? The 28th, December 28th, 2017, to pay for the police report. Here's the exchange card, the police report number that they gave me right after the accident. So now I have the police report, and I send it to State Farm, December 29th, 2017. The police report is emailed to State Farm and successfully received. The police report photos are less than 2 megabytes combined, well below the 25 megabyte limit. So State Farm definitely received the attachments. So here we have the confirming email from State Farm telling us they've received it. Thank you for contacting State Farm insurance companies, and here are the attachments. Okay? And here's the part where they know that if it exceeds 25 megabytes, it's not accepted. So now State Farm has the police report. They can see what happened, and they can see that their insured is in full liability and in full fault. January 16th, 2018, State Farm exerting pressure and coercion to settle the claim by the 21st of January, 2018. State Farm should be trying to pressure me and accept a settlement offer that permanently replaces my vehicle. Instead, they're coercing me into a rush settlement by disclosing that I have limited time with a rental car. Mind you, this is in the middle of a brutal Chicago winter. After their insured totaled my vehicle on Christmas Eve. Now they're pressuring me to accept a settlement, and now they're pressuring me with limited time on a rental. So December 29th was the date when I emailed the police report. And my ideology behind the fact that they're letting me know that, or my opinion, what I feel like they're doing is, okay, we'll pay for a rental car while we pressure you to accept a lowball offer. So if you're offering to pay for someone's car, it's because you have liability in the fact that that person no longer has a car, okay? So here we have the January 16th, 2018 mail that verifies this. This letter is in reference to the rental costs associated with the total loss of your vehicle. We will pay for any rental or alternate transportation expenses through the 21st of 2018. Any charges incurred after this date will be your responsibility. That's fucking bullshit. Pardon my French. But this is why I'm making this video, to expose the greed, the corporate greed on behalf of State Farm, and to expose the unconscionable law practice that State Farm's lawyers are practicing. Because now we have January 29, 2018. I receive a reconfirmation from State Farm declaring my vehicle as a total loss, okay? And in the email, well, I'll just read it as it goes. I received confirmation from State Farm declaring my vehicle as a total loss and confirming liability with respect to my claim against their insured. The email confirms the lowball offer that State Farm attempted to pitch to the plaintiff, me, when State Farm received the police report. I was not going to negotiate with State Farm over the phone, so I told them I would be seeking legal representation in order to pursue the amount which is rightfully owed to me. So now here's the confirmation. On the 29th of January, 2018, this letter regarding your 2013 Toyota Corolla, which has been declared a total loss by January 15th. We last spoke on January 16th, in which you advised that you did not wish to discuss the total loss settlement with you, and you would be hiring an attorney to represent you for your property damage claim. Yeah, because they lowballed me at something like $3,000 for a total car, a 2013 Toyota. Do you know how upset I was? Do you know how much emotional and mental stress this costed me? I'm not going to be accepting any lowball offer that you just kick at me. I did nothing wrong. I was sitting at a red light minding my own business on Christmas Eve. March 2nd, 2018. I received mail correspondence with coercion. If I do not reply in a timely manner, it means that my claim is in acquiescence with State Farm's correspondence. So what does that mean? I'll read it out to you. Dear Isaac, as of this letter, we have not heard from you regarding this loss. If we do not hear from you within the next 30 days, we will assume you no longer wish to pursue the matter and close our file. Please contact us if you have any questions. I am going through so much, emotionally and mentally. I'm not going to sit there and let you pressure me into taking any little crumb that you throw at me. I have more dignity than that. April 1st, 2018. I email a reply to State Farm addressing their March 2nd, 2018 letter, which is the letter where they're trying to get me to acquiesce to close the claim, the file, since I haven't spoken to them. In the letter, so I write back an email now, and this is what I say with respect to the letter that they wrote. Today, on this April 1st, 2018, 30 days, pardon me, oh my God. Today, on April 1st, 2018, 30 days from March 2nd, 2018, the contents of this electronic mail will let the record reflect that Isaac Perez is not in acquiescence to the letter dated March 2nd, 2018, labeled as Exhibit B, which I reattached in the email so they knew that I was referencing the mail that they sent me in the mail, the correspondence that they sent me in the mail. And I say, let the record reflect that Isaac Perez has paramount interest in the subject matter with respect to the State Farm claim number, the claim number. Let the record reflect that Isaac has claim to property damage and claim to personal injury. Let the record reflect that pursuant to Illinois' compiled statutes, there is a 2-year statute of limitation with respect to person and to injury to person. So I have 2 years from Christmas Eve 2017 to file a complaint with respect to injury to my person. And I have 5 years in Illinois with respect to the statute of limitation with respect to claiming damages on my personal property, which is my vehicle. Let the record reflect that on April 2nd, 2018, a fax will be sent to State Farm. The context of the fax will contain a receipt with respect to the transmission of this email. Furthermore, a certified mail correspondence will be sent with receipt of the fax transmission. Postal correspondence will be used hereafter to settle the claim in private before settling the claim in public. So I'm letting them know, like, I mean business, okay? I mean business. So now here we go from April 1st, 2018 to August 15th, 2018. State Farm informs plaintiff of Iowa statute of limitations. The defendant was driving and struck plaintiff head-on in the state of Illinois, Cook County. Thus, claim subject matter jurisdiction is subject to Illinois. Police report proves this. He wasn't driving in Iowa. Just because he has an Iowa driver's license does not mean that now the jurisdiction of where he struck me head on is now in Iowa. That's intended to deter me from continuing this claim. Like, I would go to Iowa. Why would I go to Iowa when this happened in the police report has it filed in Illinois, in Chicago? State Farm acknowledges liability with respect to their insured being at fault. Hence, they asked me to provide my lost wages, medical records, and bills that plaintiff incurred as a result of the defendant crashing into plaintiff head-on. Here we go. August 15th, 2018 now, almost 9 months since the accident. Dear Isaac Perez, we understand you were injured as a result of this loss. Well, finally, some sympathy instead of you trying to lowball me. It says, when you're ready to continue your claim, please provide the following information. complete medical and records pertaining to treatment of injuries I sustained in my loss, proof of earnings in the event of wage loss. So now, a day after, since Christmas Eve 2017 to date, the coercion on behalf of State Farm through phone and email has been focused on pressuring plaintiff to accept a settlement as soon as possible at the lowest amount possible. The mental and emotional distress as a result of having to negotiate with State Farm's lowball offers and coercion have been overwhelmingly exhaustive and pushed plaintiff to withdraw into healing and find the time and the space to regain mental and emotional health and balance. This is exactly why I didn't write back for all those months. At least you were able to catch on to that I was hurt. The total of the plaintiff lost wages due to physical injury only spanned 87 days. I was only out of work for 87 days. I'm not here to be greedy like corporate America and State Farm. Okay, I'm here to get back what I lost. And I only lost 87 days of work, which spanned from the day of I was struck head on, which was December 24th, 2017, Christmas Eve, all the way up until March 21st, 2018. Okay? Then thereafter, I was good to go again. So, plaintiff, unwilling to let a licensed attorney handle the claim, henceforth decided to take the time to file a lawsuit, pro se, by the personal injury statutory limit date of December 24th, 2019, and demands the settlement payment that is rightfully owed to plaintiff as a result of mental, emotional, physical, and financial property damages losses, which is $29,752.87. So I was not going to let State Farm lowball me, and I was really going to take this into the public arena, which I did. And it took me a good year, over a year, to be confident enough to put this through, but I actually did it, okay? So I filed a lawsuit. So lawsuit filed 2 years after I was hit head on, okay, which was the statutory limit for personal injury. Because for personal property, it's 5 years in Illinois. So technically, I would have still had another 3 years after this December 24th, 2019, to claim the damage, the loss of my vehicle. But I actually included everything in this lawsuit. So lawsuit filed State Farm and Nuruddin A. Mohammed, which was the driver that hit the defendant, the driver that struck me head on. They are served with a notice of complaint and a summons to file an appearance via USPS certified mail. And here we have the USPS certified mail. Now, the return date for the defendant to file an appearance for summons and the complaint is on February 10th, 2020. Okay, so over 2 months from the date that I filed the lawsuit. And here's the receipt for when I served State Farm. And then here is the confirmation that everything was delivered. Iowa City and Atlanta, Georgia. And then this is the document that I sent. And it reads, private, without prejudice, in response to your correspondence dated December 26, 2017, January 29, 2018, and the August 15, 2018, hereby is duly notice of the 24th of December, 2019, that with respect to correspondence dated August 15, 2018, regarding claim number 152456D44, insured Nuruddin A. Mohammed, and in Iowa and Illinois' 2-year statute of limitation, this notice hereby extends the claim in null and void of a 2-year statute of limitation by providing an on-the-record civil suit approved and entered into the Circuit Court of Cook County records on this December 24th, 2019, 2 years exact to date from December 24th, 2017, reference case number 19M1302402. And it was sent to State Farms. So I'm letting them know that I'm not going to acquiesce to the 2 years from that date. No, I'm going to actually take up the date and put it into a civil suit and null and void the fact that I would have only had up until that second year to claim any physical injury damages. And then here we have the receipt from the clerk of the Circuit Court of Cook County. It was $388 to file it. And then here is the actual filed lawsuit with the number. So now February 13th comes around and return of service filled with I filed a return of service with the Cook County clerk, letting them know that they received the summons and the complaint, as is verified by the USPS screenshots here on the tracking number that was attached to the certified mail. And I put that into the record with the clerk of the Circuit Court of Cook County. Here it is. Date of service when I served them was when I filed the suit. And then here is when I went back to file the fact that it was actually delivered by the USPS on February 13th, 2020. And up until that date, the defendant, StateFarm, still had not filed their appearance for summons. Okay? They had up until February 10th, the return date, which was a very gracious return date that I selected. So now February 28th, 2020 comes around, and the defendant fails to file an appearance by return date, which I just went over. Return date for filing an appearance for the summons and complaint mailed on December 24th, 2019 was February 10th, 2020. Plaintiff files a motion for default on defendant. So they never answered the complaint. So now I can put in a motion for default. So the hearing on motion for default is set by the court for March 16th, 2020. And then this is the paperwork that I had to go put in. You can see it got stamped by the clerk here. And then here we have the motion was scheduled. 3/16 is when the hearing for the motion for default was scheduled after I filed this paperwork on February 28th, 2020. So now March 13th, 2020 comes around, and it's 64 days since Mohammed and 74 days since StateFarm got served, as per the USPS registered mail receipts. Just 3 days before a court hearing on my motion for default, State Farm's lawyers, Bruce Farrell, Dorn and Associates, files a motion to file an appearance or otherwise plead. So Bruce Farrell, Dorn and Associates manages to get away with a technical legality and does not show up to the hearing where I am continuing my motion for default, since they didn't answer the complaint or the summons by the return date. So Bruce Farrell, Dorn and Associates manages to get away with a technical legality and does not show up for the March 16th, 2020 motion for default hearing date. Here we are. This is what they filed. Enclosed herewith, please find a copy of our motion for leave to file appearance or otherwise plead. So this is the defendant, State Farm's attorneys, Bruce Farrell and Dorn and Associates letting me know that they're not going to be physically there in court and when I go for the hearing on the motion for default. So now March 16th comes around, the date of the court hearing for the motion for default against the defendant, and plaintiff me, Isaac, myself, plaintiff attends court date hearing to advance the motion for default on defendant. Defendant is a no-show as per the legal technicality that I just noted. Motion for leave to file appearance. Judge allows a continuance. Plaintiff is missing 2 documents. I am missing the military affidavit that makes sure that the court knows that the defendant is not a member of the United States Armed Forces. The defendant, the driver, hardly spoke English. I'm pretty sure he was not in the military, okay? Especially in the United States military. Now, I don't care how mean that sounds. Those are the facts, okay? Like, those are the facts. And I did not have the proof of service, which is this paper up here. Proof of service. This paper up here denoting that I have let the clerk at the Cook County Court know that indeed the lawsuit and the summons was delivered and served properly to the defendants. Okay, so remember, now we're March 16th, I was in the hearing for the motion for default against the defendant. So what ended up happening is that I didn't have those 2 documents, the affidavit proving the military affidavit and the proof of service. So judge has ordered a continuance where plaintiff is to provide the USPS proof of service and military affidavit proving defendant is not in the armed U.S. forces. Here we are. So then this is now scheduled. I'm not too sure, but the timeline that I created will let us know now. March 30th, 2020. Plaintiff doubts that Bruce Farrell Dorn and Associates even read the lawsuit. Did they even look at the police report? Plaintiff is offered an insulting amount of $1,000. $1,000.00. If the lawyers at Bruce Farrell and Dorn and Associates actually read the lawsuit and looked at the police report, then it's safe to affirm that they are lowballing the plaintiff out of self-interest and corporate greed. Plaintiff assumes that these lawyers earn bonuses that depend on how much money they can save State Farm. Okay, so State Farm has already acknowledged that we're going to pay for your car for a certain amount of time, send us your lost wages documents, send us all your personal injury medical bills. They're trying to settle. They're letting me know that they're taking the fault. They're taking the liability, but they're offering me $1,000. As the internet slang says, GTFO. So what I deduced is the fact that State Farm's lawyers, Bruce Farrell, Dorn and Associates, will get a chunk of the amount that will not be paid out to me as it should be if they save State Farm a substantial amount of money with respect to the amount that I'm asking for. Because it's all business. Everyone is here to make money. So we got to follow the money. If the lawyers did not read the lawsuit or do not receive bonuses based on the amount of money they save their client, State Farm, then my affirmation is that the lawyers at Bruce Farrell, Dorn and Associates lowballed me such an insulting amount with the intention of insulting my intelligence and downplaying my lawsuit. And I intend to expose such a corrupt and greedy, unconscionable, and unhonorable practice. And here we have the day, again, when they offer me $1,000. Because they offered me $1,000 more than once. But here is March 30th, 2020. $1,000. This will confirm our settlement offering the amount of $1,000. Whatever. May 21st, 2020. Bruce Farrell, Dorn and Associates wants to communicate. They sent me an email. I am the attorney assigned to represent the defendant in this case. I would like to speak to you about this case and about this settlement. Please call me as soon as possible. Look, if it's not in writing, especially after I was insulted with $1,000 in writing offer, why would I call you so that you can somehow manipulate me and coerce me into accepting an offer that I don't want, that I know is not right? I know that's your job, and I'm not gonna set myself up for it, okay? Okay, so then, yeah, Bruce Farrell and Dorn and Associates expressing interest in communication and settlement over the phone. This is a red flag for coercion. Plaintiff's intelligence and intuition will not be undermined or insulted. August 21st, 2020. Bruce Farrell, Dorn and Associates files a motion for appearance and simultaneously motions the judge to vacate the legal technicality whereby they failed to file an appearance for the summons and complaint mailed on December 24th, 2019 with the return date of February 10th, 2020. Remember, I gave them the return date of February 10th, 2020, a very gracious return date. And it's up until August 21st, 2020, now that they're trying to make sure that they handle the fact that they never actually answered the complaint. They're covering their tracks with these legal technicalities. So here we have it. Order on motion, file appearance, answer or jury demand. And I'm not going to read the rest of it, but it's going to all be posted on the website, isaacversusstatefarm.com. We're going to keep going through this, okay? Here we have notice of motion. On August 24th at 10:30, I shall appear remotely before Honorable Judge Presiding, letting me know that this is actually going through, okay? August 21st, 2020. Defendant, State Farm lawyers, Bruce Farrell, Dorn and Associates, manages to weasel their way into the case and the lawsuit enters a discovery phase. Because now, all of a sudden, they've pleaded for an appearance and they have been granted that, okay? So now we're in the discovery phase where they're supposed to collect all the evidence that is permanent, that's important, relevant to this case. So plaintiff, myself, emails a PDF settlement offer. It's an attachment in an email. Settlement-8-21-2020.pdf. The PDF is attached as a link to the PDF hosted on Google Drive. It's not emailed as an attachment, okay? It's included as a link to a PDF hosted on Google Drive because it's bigger than 25 megabytes. So Google makes sure that that attachment will really be received by the other person by Google taking that attachment from it being an attachment and putting it on the cloud, on Google Drive, on Google servers. And then the person receives an email that has what looks like to be an attachment, but when you click it, it's really a link that takes you to the file hosted on Google Drive. Google Drive enables the sending of attachments that are unusually large in data size. I just mentioned bigger than 25 megabytes. Google Drive guarantees that attachments bigger than 25 megabytes in data size can be sent through email regardless of the recipient's email being a Google email or not. Google Drive is part of what the internet denotes as the cloud. The PDF settlement offer is 62.6 megabytes. The State Farm attorney defendant's email only accepts attachments up to 25 megabytes. So I am keen to this, and I'm not going to send something that I know won't be received. I'm making sure that they receive it through the use of Google Drive. Plaintiff email also includes medical records for the injury, for the personal injury sustained. PDF is attached to the email. The medical records are an actual attachment because it's a small PDF. And then the plaintiff email also includes photos. I emailed the photos that I showed you in the beginning, which actually I forgot to show you the photo of my vehicle. So I'm going to pull that up right now so you can see. Where are we here? Car crashed. There you go. This was declared a total loss, and I was sitting at a red light, and now I am fighting to expose this corporate greed on behalf of State Farm, and I am exposing the unconscionable law practice on behalf of State Farm's attorney. As you can see here in the police report, unit number 2, I was clearly hit head on while I was at my red light. You can clearly see it. So now we're going to go back to the timeline, and I have uploaded the settlement to my website. Here is the link, and then this whole file is also on the website, Isaac versus StateFarm.com, Isaac-versus StateFarm.com, and I have also uploaded my medical records, which I shouldn't have to, but I'm forcing myself to provide this out in the public so that something can get done about it, because it's ridiculous, the convolution and the coercion, the pressure, the unconscionable law practice that is going on right now. Like the proof is in the pudding. They're completely ignoring the police report. So then here we can see in the email, I'm showing you that I attached those attachments, the settlement, and then the photos. The photos are attached as a zip file because there's a lot of photos in here. You can see the proof of Google letting me know that the file is bigger than 25 megabytes and thus will be sent as a Google Drive link. So there is no excuse as to how they can say that they did not receive it, okay? Google's making sure they receive it. So then here is a screenshot of the photos archive or zip file that contains all the photos. And as you can see, anyone with a link can download this. It says viewers can download, okay? Sharing, anyone with the link. The link was sent, okay? So then, lack of effort in 2020 when dealing with email attachments is what I call being lazy on purpose. Google search only requires a few keystrokes and a mouse clicks in order for you to find out something that you don't know. So you could have put in, what is a zip file? And they would have told you. If you download it, if you double click it, it'll open a folder with a bunch of folders, with a bunch of photos. So then here I have proof that the settlement PDF file is viewable through Google when you click it. See? Open through Google Drive, and then here is Isaac Perez, MO, the amount, sum total of $31,000. I put in now all of the little things that have been adding up. I had to go to Kinko's, I had to pay for an Uber, I had to do this and that. I'm adding it all up. So then that's why I'm saying now, this is now what it's been adding up to, $31,000 and change. And here's the file sent through Google Drive. And then within that very settlement file where I denote how much I am seeking for in the settlement, how it's broken down, court fees, certified mail fees, police report, parking, FedEx Kinko's printing fees, lost wages, pain and suffering, property damage. I'm listing it all. I also have the police report in that settlement PDF. And then I have all of the information that State Farm originally asked me for when they said, oh, we know you're hurt, send us the information with respect to your lost wages. It was all sent in the settlement PDF that was emailed on August 21st, 2020. It was sent to State Farm's attorneys, Bruce, Farrell, Dorn, and Associates, okay? Here it is, here it is. And then within the same settlement, I included the photos that can be confirmed via the police report. Okay? I am the white car. White car is plaintiff. I'm sitting at a red light. Okay? This black car is the defendant. He did not drive on his lane. He drove onto my lane and hit me head on. He was probably going faster than 15 miles an hour. It clearly says that. 15 miles an hour is the speed limit. And if he wasn't, he should have been going 5 to 10 when there's snow on the pavement. Like, you can feel the lack of control in the vehicle when it's raining, when there is snow and there's sleet. You can feel it. He was being careless and negligent in his duty and responsibility in operating a motor vehicle. Here it is, the photos in the settlement PDF that were emailed to them. It's all there, it's clear as day. Police report, documents from wages lost, medical records, everything is in there. August 21st, 2020. Then August 25th, 2020, the defendant confirms email attachments that I just denoted, okay? The defendant notes, however, the defendant denoted the inability to open the archived zipped photos.zip file. Okay? Downloading the zipped photos file and double clicking it opens up the folders with all the photos. This can be done on a Mac, on a Windows, or on a Linux. This zip is a universal archiving method on all computers. They automatically recognize it. All you do is double click. You don't need to download software. You don't need to do anything. Defendant fails to disclose any problems with the other files attached on the email, which were the medical records, the settlement, and there was another medical records file here. So there was 2 medical records files and the settlement that they did not denote to me that they did not have any trouble opening. So logically, they were able to open it, okay? So defendant fails to disclose any problems with the other files attached to the email. Other files include settlement offer and medical records. Defendant chose to only click photos and stop there. Okay, they clicked photos inside the link and then said, we can't see anything. We shouldn't really try. We're just not going to try. So they stopped there. Defendant did not attempt to unarchive, unzip, and view photos. Defendant did not attempt to download the photos that zip file. They just clicked it and said, no, there's nothing there. I don't have any common sense. Maybe there's something in there, but who knows? Which actually, when you do click it, as in the screenshot above that I've included, it shows you that there are photos in there. Well, I'll show it to you. It looks like it's in the... If we continue, it'll be there. Here we are. Oh, it was right below that. Okay. So plaintiff affirms defendant was only printing from the browser while viewing attachments in browser. So this is what they were looking at, okay? They clicked on the photos, that zip file. They saw all these photos, and they tried clicking them. I said, we can't see them, so we're not going to try it. So, plaintiff affirms defendant was only printing from the browser while viewing attachments in browser. Archived zip files are not viewable, are not editable within internet browsers. In the same way in which you can open and edit a video file in your internet browser and edit it frame by frame. So you cannot take a DVD and say, hey, Internet Explorer, Chrome, whatever internet browser you're using, I want to edit this movie. No, it's made for browsing the internet. So browsers are not able to open zip files. You have to download them, double click, and they open on their own. So on August 26th, after I received that email, plaintiff provides access to photos via internet browser on the same domain from which plaintiff has been emailed defendant. Let me explain. This is my email, isaac@nth-vision.com. This is in response to them letting me know that they cannot see the photos. All, as in all photos have been, is a typo here. All images have been made downloadable in their full resolution on the domain that I host the email address on. So http://nth-vision.com, and then I gave it a subfolder with reference to the lawsuit number 19M1302402. Example link. I give them an example. If you click the folder, you'll be able to see photos like the police report photo. So I sent them the direct link, and this is what it looks like when you click the direct link. You can just click on the photos and view them in your browser. So defendant follows up on December 9th, 2020, after the December 26th, 2020 email, and they follow up with plaintiff is made to jump through hoops in the discovery process through the use of legal technicalities, Rule 213 and Rule 214, in order to deter plaintiff in civil suit proceedings since plaintiff is pro se. Now, what does this mean? What this means is that State Farm has had the police report, okay, since December 29th, 2017. Okay, that's 5 days after State Farm's insured hit me head on while I was at a red light. Now, what the State Farm attorneys, lawyers are doing is they want me to go through a deposition. They want me to show up to their offices and be, and like, what's the word? Be in the record that everything I'm saying is true. They're making me jump through hoops in order for me to claim what is owed to me. Like, you want me to show up to your office with what car? Like, it's ridiculous. So, here I expand on it, and I'll go through it thoroughly, okay? State Farm, the defendant, failed to originally answer the notice of complaint and summons to file an appearance that was graciously set forth by the plaintiff for the return date of February 10th, 2020. However, Bruce Farrell Dorn and Associates is persistent in putting plaintiff through the ringer of an in-person deposition in the process of discovery when the police report should suffice. And the correspondences dated January 29th, 2018 and August 15th, 2018, where State Farm lets me know, hey, let me get your medical records, your lost wages, and everything in between because we're in full fault and taking liability. So, like, what is the problem? Why are you trying to corner me in court into giving up on my own case when I didn't give up when you guys were lowballing me before I even put this in as a lawsuit? The proof is in the pudding. I have showed you the police report. Okay, so now I reiterate all of the emails that were sent to State Farm and or the lawyers with the information that is sufficient enough for them to be like, oh, okay, this is what he was earning for 87 days and he didn't earn it. And here's what you should get paid. Like, I'm not sitting here being greedy like them, trying to cut me out of the most amount of money they can cut me out of. I'm asking for what is rightfully owed to me. Bruce Farrell Dorn and Associates is practicing corporate greed in an attempt to strong arm plaintiff into submission through the use of legal technicalities. Bruce Farrell Dorn and Associates fights to deter plaintiff from seeking the judgment and settlement that is rightfully owed to plaintiff. Bruce Farrell Dorn and Associates fights to insult the intelligence, honors, and merit of a man who was hit head-on while at a red light. It is quite obvious that Bruce Farrell Dorn and Associates have intentionally ignored the truth of the subject matter as entered into record by the police report. And as plaintiff has provided verifiable records of lost wages, personal injury, and property damage. And I sent all of that in that settlement PDF that I spoke about that was sent through the Google Drive attachment link on August 8th, 21st, 2020. And on August 15th, State Farm correspondent to plaintiff before the lawsuit was filed provides the proof that State Farm's acceptance and liability in full fault on behalf of the insured, Mohammed. Nuruddin Mohammed. State Farm is using Bruce Farrell Dorn and Associates as a buffer to minimize and intimidate and use the coercion in order. Pardon me, I'm going to restart that. State Farm is using Bruce Farrell Dorn and Associates as a buffer to minimize the amount that is owed to plaintiff through the use of legal technicalities and intimidation through the use of coercion in order to have plaintiff accept a quick and insulting $1,000 settlement. And the settlement is in the email that they sent me on March 30th, 2020. So now we're at December 9th, 2020. So August 15th, 2018, State Farm correspondence to plaintiff before lawsuit is filed proves that State Farm takes liability and acceptance in full fault on behalf of the insured. We understand you're injured, send us your earnings and medical records. Why would you offer to pay for this or have me send all these files to you if you're not liable? You're clearly liable. You as in State Farm and lawyers, the defendant. So now we're at December 12th, 2020. Plaintiff responds to December 9th, 2020 defendant email by disclosing COVID-19 personal and family emergency. So they sent me an email. Where's the email? I should have it right here. Is this it? What's the date on this? This is a January email. Well, it looks like I accidentally deleted it, but I don't want to go through my email and show you guys, but I received an email, okay? And then I wrote back, as you can see here. For the record, my apologies. My family, as well as myself, have contracted the coronavirus. I've been taking care of my mom since she got it in late August, and the symptoms came and went for myself in October, but stayed throughout November. The COVID migraines, as they call them, have been unbearable, coupled with the fatigue, and it is very hard to get anything done other than lay in bed. I attached the COVID test results for my mom because when I went to go get tested, I tested false, and I think that was a false positive, but I was the one who gave it to my mom because I have had COVID since New Year's Eve 2019. Okay, several days after I filed a lawsuit, I contracted COVID. And I didn't tell anyone because I was fighting it the whole 2020. It was not something that you want to openly disclose to someone, okay? You're gonna focus on feeling better and you're gonna focus on trucking through it. And unfortunately, I was in bed for almost 2.5 months from January 1st, 2020 up until Valentine's Day, 2020. And then the time thereafter, COVID came and went, okay? There was weeks where I was doing okay. There was weeks where I was doing better. There was weeks where I felt like crap. And then during one of those weeks, when I was with my mom, I gave her COVID and I thought I just had a cold from the AC from the night before. False. Because then thereafter, she started to describe to me the things that I had been experiencing throughout all of 2020. So I go ahead and I email this to the attorneys of State Farm. Okay, I tell them on December 12th, look, I've had COVID. Like, I don't know what to tell you pretty much, you know? And here's the proof. So then I had not sent anything through the mail because we had been communicating through email. I hardly have any life force when I had COVID. Why would I go out and intentionally but unintentionally give it to someone even if they're giving me a hard time with this lawsuit? So out of respect, like, I didn't mail anything because I didn't want anyone who received it to contract COVID. So you should thank me for that instead of trying to make me look like a bad guy because you did not receive any mail from me. However, you did receive email correspondence with heavy data, documents. So January 22nd, 2021, plaintiff is made to jump through hoops through the use of legal technicalities in the discovery process in order to deter plaintiff claim settlement and judgments. Plaintiff is pro se. Why do I say this? Because we had, I believe, 2 court dates, or 3. One of them they didn't show up to, which was the appearance where I was going through the motion for default against the defendant. However, in the other 2 court dates that we had, the attorney for State Farm said several things that jumped out at me that highlighted to me that they are not taking me seriously because I'm not a licensed attorney. One of the first things that they said was, Your Honor, he's not an attorney. He's here pro se. Trying to throw me under the bus. The clerk already filed the suit. We're already in court. Why are you trying to insult my intelligence? So this really mentally and emotionally put me in a place where I don't want to talk to you when I know that all you're going to do is somehow coerce me or undermine me or just think that I'm just some fucking idiot. Like, that's not cool. So this is why I'm making the video. January 14th, they filed this order to compel that I have to answer to written discovery by January 28th and present for deposition on February 25th. Like, honestly, all of 2020 was so hard on me because of COVID. I hardly even checked my email. Like, this lawsuit was hardly on my mind. What was on my mind was trying to stay alive. Plaintiff is being strong-armed by Bruce Farrell Dorn Associates. Bruce Farrell Dorn Associates has had all the necessary documents to make a just and honorable settlement offer. However, Bruce Farrell Dorn Associates is focused on plaintiff's lack of law license in hope that the pro se plaintiff gives up. Plaintiff did not give up fighting COVID-19 for a whole year. Why would plaintiff give up fighting now? Why would plaintiff give up now? State Farm correspondence to plaintiff before lawsuit filed clearly proves State Farm acceptance and liability and fault on behalf of their insured, Nuruddin Mohammed. And then I just go on to reiterate and be redundant with the emails that I sent that had all the supporting documents that State Farm asked me before the attorneys were brought onto the case. And I just reiterate that here with more visual proof. And then on January 22nd, I reiterate again that the police report was sent to State Farm on December 29th, 2017. So they must have had given it to the attorneys. And it's as clear as day in the police report. Who's at fault? Is it the guy at the red light or the guy who got hit head on while sitting at a red light? Bruce Farrell Dorn Associates received redundant copies of the police report in the following emails dated August 21st, 2020, August 26th, 2020, and the State Farm had the police report since December 29th, 2017. If Bruce Farrell Dorn and Associates was not in possession of the police report was included in the settlement PDF that was attached as the Google Drive PDF link. So it was already there. And it was also sent in the email. I'm just reiterating the fact that have had these documents, but they're putting me through the ringer of the written discovery and the deposition, and this is ridiculous. Like, why should I go through all this work to claim what is obviously mine? Like, this is what I'm calling legal technicalities and corporate greed on behalf of State Farm and their attorneys, Bruce Farrell Dorn and Associates. So now, January 28th, plaintiff compels to the order set forth by defendant, which was sent to me in an email on January 22nd, 2021. Oh, geez. So plaintiff compels to order set forth by defendant. And I provide the documents they're asking for in person. I go to their offices, downtown Chicago here. I took photos and I sent the photos as proof of me signing with the doorman at their photos. However, the doorman tells me that their offices are under construction. What a coincidence. So what are the chances the offices are closed as they are under construction for a full renovation? So I was just sent on a wild goose chase. As per the January 22nd email, 2021, that I have to go do this in person at their offices, but what a surprise, their offices are closed and there's no one there and no one's going to be there because they're under construction. So then I email the documents and I let them know that I tried. I attempted to stop by the offices today and drop off all my paperwork with respect to the discovery deadline, 1/28/21. The concierge told me the offices were under construction. No one would be there to receive me. I attached photos as proof. I will be mailing everything. However, the photos attached will be the proof I showed up to the offices as per court order on the deadline. And I attached the deposition that I filled out digitally. Them wanting me to give them to them in person and me be there in person is just having me do more work, trying to tire me out so that I don't collect this money that is owed to me. They didn't even respond to the return file that was originally set forth, and they didn't even care to fight me on the motion for default against them. All they're doing is they're trying to tire me out with these legal technicalities. Bruce Farrell Dorn Associates is making this lawsuit overly convoluted. It's clearly about how much money they can save State Farm. Why would plaintiff settle for $1,000 when plaintiff has provided police report to prove defendant liability and plaintiffs incurring physical, property, and financial damages? So how much does Bruce Farrell Dorn and Associates stand to walk away with if they can save State Farm from paying out the full lawsuit amount? Like, how much do they walk away? What is their commission for not letting me walk away with what is rightfully mine? This is why they're putting me through the ringer. By the same logic that Bruce Farrell Dorn Associates is taking in order to have me do an in-person deposition and give them all these papers in person. By the same logic that is happening, the plaintiff, should be able to cross-examine and obtain a written and in-person deposition from the driver, Nuruddin A. Mohammed, and he should do it at plaintiff's legal resident address, my home, while Nuruddin A. Mohammed is connected to a lie detector machine. Because this is the same amount of work that they're making me go through to collect what is rightfully mine. So then I should be able to cross-examine the driver, so the driver just like puts it all out there. Because the lawyers weren't there, State Farm weren't there. So you guys are just trying to have me run in circles, have me, go on a wild goose chase, throwing curveballs at me, like throwing these legal technicalities at me, hoping I strike out, hoping I give up, hoping it's over. By the same logic, I should be able to cross-examine the driver, Nuruddin A. Mohammed, at my home residence. And he should be tied up to a lie detector test. So then, so now what they have done is, what they tried to do is they set forth a motion to enforce a barring order on the plaintiff, on myself. And what that means is that they are locking me out from providing all of these documents in trial in front of the judge. That was the very reason why I set forth this lawsuit. So I can have an honorable judge look at the facts and put these unconscionable, corrupt lawyers in their place. Because it's as clear as day. So, okay. So that's all there. I'm not going to read throughout. Okay. So I will read through this. Okay, when they sent me the motion to enforce the barring order, I found this kind of funny. Was that it was filed on February 10th, 2021, but it was emailed to me on February 17th, 2021. So they waited a whole 7 days. And their law software template had created that file on the 5th of February. So it was created on the 5th. It was filed on the 10th, and it was emailed to me on the 17th. If you're already e-filing something, why can't you email it to me the very same day? Like, was this done on purpose? So, February 10th, Bruce Farrell Dorn and Associates is persistent with the legal technicalities in deterring plaintiff from seeking a just settlement. Bruce Farrell Dorn and Associates motions the court with a barring order in attempt to prohibit plaintiff, deny plaintiff the very goal of the lawsuit, present the evidence to an honorable judge, present the evidence to the people. So this is why I'm making this video now. I'm presenting this evidence to you, the people. Present the evidence to a court brought forth by the plaintiff, the man, the administrator to the legal title, Isaac Perez. Bruce Farrell Dorn and Associates seek to bar plaintiff from providing imminent evidence to court in which the defendant is exposed as fully liable and in fault of the $29,752.87 demanded in the lawsuit. They're trying to lock me out of providing the imminent evidence to the court so that I look like an idiot and can't prove that I am owed this amount. When State Farm has had the police report 5 days after I was struck head on. Bruce Farrell Dorn and Associates argues the plaintiff has failed to comply with tendering written discovery and being presented for their deposition, and therefore the order which was entered January 14, 2021 by this court is in full force and effect, and plaintiff is barred from testifying and presenting any evidence at arbitration and trial in this matter. So this is not official yet. This is the motion and the order they're trying to get the judge to agree on. So then, to reiterate on the same logic that I am being put through the ringer by answering all these questions through the deposition and giving them all this extra time and effort that shouldn't be needed, by the same effort, I should be able to ask the following questions to the driver, Nuruldin A. Mohammed, at my home residence. Okay? I should be able to ask these following questions. Does Nuruldin A. Mohammed remember verbally accepting fault and liability for the head-on collision into my vehicle? As I angrily pointed out to him, what the fuck? I am at a red light. What the fuck? What's your insurance? That was the first thing that I said to him when I got out of my car. Does Nuruldin A. Mohammed remember Nuruldin A. Mohammed's driver's license is issued in Iowa. What was Nuruldin A. Mohammed doing in Illinois on Christmas Eve of 2017? Does Nuruldin A. Mohammed remember Isaac Perez obtaining his insurance information? Because clearly I was able to put in a claim right there on the spot with State Farm. Does Nuruldin A. Mohammed remember that it was Isaac Perez who called the cops right away? Does Nuruldin A. Mohammed did Nuruldin A. Mohammed read the rules of the road for Iowa? Does Nuruldin A. Mohammed remember reading the rules of the road where it informs you in adjusting your speed and braking with respect to less than ideal road conditions? For example, driving in the snow or rain, hydroplaning, black ice, and the obvious lack of traction on the road, as any derivation of water between the tires and pavement acts as a lubricant. Does he not remember reading that part in the rules of the road, in the little booklet that says, look, when the weather conditions change, like, obviously you're not going to have the same traction? Because I clearly remember that when I was 15 in driver's ed. Does Nuruldin A. Mohammed remember that I filed the claim right away after the cops came and left? Because I was hoping that I would have a police report number to give to the cops. But no, I had to go get the police report and then give it to State Farm. What speed does Nuruldin A. Mohammed remember he was driving at? How many other vehicles were out at the time of the accident? What was the speed limit that reads on the turn on Ridge Avenue? Because I took a photo of it. It's 15 miles per hour. On the morning of Christmas Eve 2017, while driving and before striking plaintiff head on. Was Nuruddin Mohammed not aware as he is driving that there was a clear 1 to 3 inches of snow? Was he not aware of that? And that it continued to snow? So why did he not adjust his driving? Was Nuruddin Mohammed not aware that the vehicle was not as responsive as it was with dry, non-snow driving conditions? So now we show up to court, March 19th, 2021. And the lawyers for State Farm are pushing to have me barred out from being able to present my evidence in trial. However, before that part even comes up, like the judge asked me, like, what's up? Why haven't I responded to them? And I am brutally honest with the judge. I explained the severity of COVID-19 and how it impacted my life. And the judge allowed for a continuance. Like, because I'm speaking the truth. Why would I waste all this time? I'm not here to waste time. In fact, State Farm has wasted my time. I was out of a car. I was out of a normal life in the middle of winter. I was out of earnings, wages lost. Do you think that I woke up on Christmas Eve 2017 and said, today is a great day to become an insurance scammer and work my way up to a lawsuit so I can scam them? Like, do you think I plotted this for 4 years plus? It's absurd. It's ridiculously absurd. I'm asking for what is fair and just and is the right thing that is owed to me. State Farm declared my car as a total loss. I no longer drive that car. I no longer have access to a car. I borrow my dad's minivan. It's not my car. So here we have the proof that the judge allowed the trial to continue. I was not barred out from presenting my evidence. In fact, they had put in there that it was just a file amendment or an additional amendment pleadings. So now we're July 23rd, 2021. And now the defendant files a motion for voluntary dismiss, and that court date is, I guess, tomorrow or today, if it's already August 9th, 2021. Okay? They're trying to get me to what they're gonna focus, what their focus for this court date is having me be put in a position where it's, oh, he took way too long. But look, I am operating well within all the time that I should be given with respect to how much I went through as a result of State Farm lowballing me, pressuring me to accept a fast settlement, and then being lowballed again by the attorneys with the insulting amount of $1,000 on a $29,000 plus lawsuit. Like, do you understand how anyone in my position, like, it's not something that it's hard to handle, because you're sitting here trying to do things right and ask for what is owed to you, and they're sitting here trying to slap you around and make you look like a fool. So now, August 8th, 2021, plaintiff launches a social media justice campaign to expose the corporate greed and use of technical legalities on behalf of State Farm and Bruce Farrell Dorns and Associate in order to strong-arm plaintiff into giving up interest in lawsuit. So I have done it. This is the video. This is the social media justice campaign that I'm going to continue to work on, and I'm going to continue to put out videos where I'll dive deeper in depth into all this that's going on, because I'm not going to stop. Okay? It's not right what they have done. It just isn't right. You offer someone $1,000 after you total their car. That's effed up. Okay? And then you make me look like I'm not knowledgeable enough. Like you make me try and look like I'm just a fool. That's not right. So I'm going to take my time. I'm going to take my time so that I can put in the intelligent thought and the intelligent integrity to expose the corporate greed to the world, because one too many people have been fucked by insurance companies. Okay? And no one stands up and authentically speaks the truth on how messed up this is. So even if I reach one or two people, if anyone out there has State Farm, boycott them. Okay? If this reaches anyone who is thinking about filing a lawsuit, drop a comment below. Let me know. I'll share all the knowledge that I've gained with you for free. I'm not here to make money. I'm here to spread the truth. I'm here to claim what is mine in an honorable and just way by exposing the corporate greed on behalf of State Farm and their lawyers. Thank you.